Item number 2.
This matter was from the 12th. So there was the issue of 73 or 74. Rocket wanted this matter to come up on today. Rocket said that something may happen today. That there was an issue whether this was 73 proceeding or 74 proceeding. And that's why Rocket wanted this was before Rocket from the 12th. In fact, the issues, the Rocket can we see the order? The Rocket said that we wait till Monday, something may happen. About this issue of 73 and 70.
We were going to deliver a judgment on that particular. Why we said it something?
This is 73?
73 and 74 issue and relating to the instruction 2023.
Let it come next week.
No, in this week. Let's just go through it today. There was one matter which is already been heard. Is the contemplation, we are contemplating to deliver a judgment, so we just thought in that way.
So,
2 days I could not get time to go through it. It is all.
I bought on.
So day after, when it is a tax day?
19.
Thursday you keep it. I will go through.
19. Item number 3.
May I please write out slide? If you lordship will look at the order of assessment at page 38 to 40 below, annexure 3 below, I want to guide this for a moment below. Let's say arises out of audit assessment below. There is the audit.
How much?
That is also answered by your lordship bills. But I am giving the lordship my lordship order.
Maybe we are getting wiser day by day. So tell me how much.
My friend has also become wiser. He is very fair to lordship. Your lordship is much fairer than my friend also. Your lordship.
Right?
Everything from my lordship order. Your lordship directed that parity to be maintained. No, parity. That's the you allow me. Your lordship directed. In the event the preconditions of pre-deposit are complied with, then because the rest of the demands are given paid because. Clearly said, time maintained.
How much?
No, you kindly see my lord's order. Just for a moment.
You agreed for 10% and your lordship 50%.
Sahu, I learned in these years only one thing, that interim orders are not binding on courts.
Yes.
Even the court which passes. I think that is the.
I did not utter.
No, I
was just expecting.
My learned senior brother will.
Your lordship knows.
You understand that.
10%. No, why I am saying sure. Your lordship own orders. Because it's a peculiar case. But if your lordship will see
That's why the peculiar approach has to be made.
Just 1 minute. I will not take my lot time. Page 74 for a moment, yours. But I understand. Page 74. A coordinate bench has passed over. Page 74, Virat. Why your lordship passed order and your lordship will find from page 74. A moment, Virat, sir. Yes. Paragraph 5. This coordinate bench has directed. In the case of this petition, this year and very same case. Accordingly, while you refrain from exercising the jurisdiction over this matter, grant liberty to petition to file an appeal.
So there is no finding, there is no ratio of law which is laid down. If you read up to paragraph 4, it is only the recording of the submissions and surreptitiously jumping to a conclusion at 5. So it can't be deduced that what is a ratio. It's a relief which has been granted, but it cannot be said to be a declaration of law. You know, Mr. Sahu, better. Why you are
the case, same case belongs. It's the same case, same period. And same fact belongs. Same period. Your lordship has to read only in paragraph 5 along with page 77. Because how the lordship order is complied with.
Why?
It is of the year 2012-14, the assessment. at that time, entry tax matters, you know better how they were in doldrums.
Better.
Very, subsistence of the act itself was in a doldrum.
We are not done that. Those are different
So
things.
now it is clear.
Fine.
Now
we are not done that.
So now liability subsists. As
This is
apparently,
only factual.
only thing is you may take other pleas of
This is only factual. And even lots of directions has been complied with by the appeal authority by admitting the appeal, recording clearly that the preconditions have been clearly complied with.
so once appeal is disposed of, you will get back if it is in your favor.
May I say, the Lawrence Commissioner, yes, only ground he has taken for rejecting the stay is that you have not filed C form. And as a matter of fact, a matter of record, entire C forms have been filed. 240 crores. Entire C forms, and that is how your Lordship, at page 74, para 5, directed the appeal authority to consider and accordingly, direct the petitioner to comply with the precondition pre-deposit. I have complied with. But is admitted, and page 77, appeal authority has recorded my compliance to pre-deposit. And now appeal is ready for hearing for tribunal. Maybe posted barely after 2 weeks or 1 week. So in view of this, despite of the fact that I am not liable, you are fair, I know, you keep quiet. Even if my friend is fair, I am still offering 10%, and 10% will be too much because 2 crore 56 to 56 lakhs is the tax, disputed tax. And that arises only because of the form which I have already given below. That is the peculiar circumstance. So 27 lakhs it comes. Whatever I have paid, still 27 lakhs. I think my lords, this is not a bad, but I think bad thing offer can be made at my end. Because I understand everything and still, lords, from my end, I am convinced my conscience, I will say because of lordship direction only, I have told my client to pay this penalty. Otherwise, nothing is there. So your lordship has directed to maintain clarity. Wherever your lordship, my lord's order, I do have with me. Your lordship probably have got one. My lords have said at para 3, I am very para order your lordship have passed. Wherever conditions of pre-deposit are being complied with, there is no recovery. Essentially, that your lordship, and here I have complied with, and that too by an order of the collateral bench. So when I have complied with the precondition order, as per para 3, your lordship direction.
So why you are apprehending?
Right.
If the statute has put the restraint on them from proceeding to recover the remaining above, once you confirm or comply with the statutory,
No, statute, unlike VAT, under entry tax, there is no amendment. That is why your
if there is not, then it's a discretion or application of mind by an authority while granting the stay. You can put a conditions. And now the conditions have to be judged in the context or on the facts and circumstances.
Exactly.
There is nothing. So now we are really, once we exercise the discretion, which is vested into the authority, then in that event, what to do?
That is why your lordship said, para 3. If you have complied with the conditions, then the 20%.
That was the relation to something else.
No, only that. Para 3, your lordship can see. If the precondition deposit complied with, no recovery.
So that is, there is a bar.
So here, that's my, he said, I have complied with you.
But why you are apprehending them?
Because unless your lordship's direct operation of this order,
They can pass the order. They can't proceed.
they have not. Already, Annex 18, we including for lordship bills. Commissioner says that you have not gone into anything, rejected. Even if on the ground here rejected, doesn't stand, my lords. I have given all the forms. And the authority himself also says in order, yes, you have given. You know, you kindly see page 77. I have given all the forms. On the matter of record, my lord, those are verified. And after verifying the return forms, they directed that this much free deposit you have to make. I have paid. What do you say?
Lordship, may utilize your lordship's discretion.
What you utilize?
Permission of
What is discretion?
Lordship, my lord senior says 10%. Let it be some more high.
How? How much?
As your lordship, I leave it to your lordship. I leave it to your.
You are exercising discretion there.
Your lordship, I leave it to your lordship. Your lordship.
Basis for addition in the OS. And only the point. I am afraid unless 240 what I have given examined as per your direction, only that is considered because that may stand conflict. That may be conflicting. Or your lordship direct. What conflicting? Because in consonance to the earlier order of the coordinate bench, because whatever forms have been submitted,
These are not a final form. There is nothing where the law has been declared that this is what the interpretation of the section is.
we are now at the stage of compliance only.
It's a discretion which varies.
Correct. But now
On
we
the
have
basis of a facts of each case.
the interim stage because appeal is there.
But say interim stage that is
So sure.
And I'm in between.
Only hours are there 20%, you say.
That those are separate. Those are different. My lord senior knows very well at that time.
I don't argue. I don't think.
No, I don't want to argue.
100%.
the discussion.
Sir, I hear from my lord so that I can convey for compliance. That is great.
May you will get it. How much of a percentage you will get?
Your parity is 20%, I offer 10%. That is how we stand, lords. And your lordship's clear direction is, I don't say, your lordship this is always there.
I think now I have to restore my elder brother's opinion about second appeal suit. Court number 2.
Your lordship knows everything, but with passage of time,
Month of March.
the wisdom changes, everything changes, approaches. Now I am at the time when the matter is now ripe for hearings. Very shortly also at the hand. And nothing is remaining.
Will not request the disposal at another.
Exactly. That is also, yes. That is the interest of both wills. Interest of both. That is the interest of both. That
No, they
also,
can't stand in the way of expeditious disposal.
Very
They can't
correct.
say anything on
very fair. Yes. Correct.
You not say.
What ground?
If issue number 1, your lordship, it's error apparent on the face of the record.
What?
Error apparent on the face of the record.
What is the error which is apparent on the face of the?
Yeah, I'm coming to it. Your lordship. The input judgment suffers from error apparent on the face of the record, warranting review under section 47 rule 1 CPC. And the sub-issue is whether the judgment erred in expanding section 24B jurisdiction beyond granting aid matters. Next is whether the judgment created unconstitutional discrimination by treating the petitioner differently from similarly situated persons. Next is whether the judgment failed to consider the judicial precedents cited during the arguments. Whether the judgment overlooked material facts like age, service, and pendency of the matter. Whether the judgment ignored constitutional questions under Article 14 and 16. Next, your procedural irregularity. Whether the proceedings suffered from violation of principle of natural justice warranting review. Sub-issue. Whether the petitioner was afforded adequate opportunity of hearing. Whether non-consideration of application for object listing amounts to procedural irregularity. Whether the amicus curiae is the substitute of the petitioner.
No.
Next, whether delivery of 22-page judgment with a notice violates natural justice. Next, next issue, your lordship, whether the constitutional questions under Article 14, 16, and 226 can be effectively adjudicated only by this honorable court and not by statutory tribunal. Next is efficacious remedy. Whether tribunal remedy is efficacious for a 59-year-old litigant, 8 months to retirement after 22 years pendency of issue and 6 round of litigation. Next is manifest injustice. Whether relegating the petitioner to further litigation would result in manifest injustice, defeating the very purpose of judicial remedy. Well, your Honor, next I'm coming to my arguments. Discrimination, violation of Article 14 and 16. My submission is that
Does it come under the purview of the review? Because that was considered Article 14 and 16, and if it is decided maybe wrongly. But this can be termed as the erroneous order, not an order containing error apparent on the face of the.
But your lordship, there is judgment of the Honorable Supreme Court.
Yes, in the review and info.
Let me. Your lordship, this is the judgment in civil appeal number 5454 of 2019, your lordship. The order has been passed on 7th of November 2025. In para 1, it said Article 141 of the Constitution of India declares that the law laid down by this court binds every court in the country.
No doubt on the proposition.
Yes, next. Appellate jurisdiction exists to correct errors and to settle the law so that like cases receive like outcomes.
No doubt.
Next, your lordship, the judicial discipline requires courtesy, restraint, and obedience to binding precedent, even where a judge is personally unpersuaded. The lawful course is to apply the precedent and, if needed, a record reasons for inviting a larger bench to reconsider it. Next is your lordship, the stare decisis et non quota mover, which means to stand by decision and not to disturb settled matters. In the next para 4, your lordship, a judgment that attempts to resist binding authority undermines the unity of law, burdens litigants with avoidable expense and delay, and invites the perception that outcomes depend on the identity of the judge. In a constitutional judiciary, it is the law as declared. So, therefore, it was held that we restate the simple duty of courts, apply precedent as it stands.
It's a doctrine of precedence, no doubt. There is no difficulty of that.
But your lordship,
Under the review jurisdiction, sir, the difficulty is the review jurisdiction is distinct and different from the other jurisdiction. And if in an application under Article 226 per se, as you find it here, whatever you are arguing may be a good ground that doctrine of stare decisis no doubt about it. Settled the proposition of law should not be unsettled. Principle is, which is prevailing longer period of time should not be disturbed. All these things are known. But in a review, the difficulty is in once the court has considered the point, decided if correctly or incorrectly, no incorrect, wrongly, thus it comes under the purview of the review. It may be a erroneous order or a judgment, but not a judgment containing error of the fiscal.
But your lordship, in my perception, this decision of the apex court allows this honorable court to go for review. That's just one ground. There is another ground, that is this Article 14 and 16 have been violated.
No problem, there is no difficulty. There's a equality principles and equal opportunity in the public employment. No problem. That was taken into consideration.
And
This is a question of forum. We decided that you may jump in the forum from at one point of time you went there, again here, coming here. So
Your lordship,
the stability of the forum is also one of the hallmark of the judicial dispensation. So we relegated you to the tribunal and educates or ventilates all the such points. We have not decided on.
but your lordship has heard that I'm choosing the forum of my
This
choice.
is also capable of deciding Article 14 and 16. There is no difficulty. It's a very fundamental rights. If there is any infringement, the court will definitely, with whoever is the court will take into consideration.
But your lordship, choosing the forum is not my convenience. It was
That is what may be wrongly held by us, but we have held so. So if you are agreed, you can go.
but your lordship,
Correctly. That is what the law is of the review jurisdiction.
but I'm at the age of 59. My retirement within 8 months.
I understand, sir, what I mean.
So relegating me to the lower forum will take more time. By the time I will be retired and no benefit.
Yes.
Your lordship, I'm filing the written note of submission along with
Please file it.
the decisions.
Consider.
Please kindly consider.
You have those line of judgments on our review jurisdiction.
Yes.
The error occurs on the face of the.
Everything.
The
two judgments.
Judgment and a judgment.
2013 and 2023, both judgments I have given.
Your lordship, I may be supplied a copy of those judgments, please.
Give
I'll give.
it.
Left hand top corner, I have mentioned the page numbers.
Your lordship, this may kindly be given another date for final hearing.
We choose. The software. Yes.
Item number 17.
Honors, on behalf of Dr. J.K. Lenka, kindly pass over this matter. On behalf of Dr. J.K. Lenka, kindly pass over this matter. Arvind counsel is on his legs in the other court.
Item 18.
The applicant challenging the increase order dated to 13/2/2026.
Yes. So forest land is road you wanted to use. The forest road you wanted to use for transportation is the stone of concern. And they have revoked or cancelled that permission. This is the case.
No, my lord, it's an election dispute, you know. Election dispute, you know.
Which party you have called?
WH 404 of 2026.
What are they doing?
Village.
My lord, there is delay of more than 4 months in filing the election petition
You
and
were
the
opposite that.
my statutes state that it should be filed within 15 days. Statute says so.
His daughter? No. So, any brothers serious?
Yes.
Election petition under the representation of Nupul Sir.
Orissa Gram Panchayat Arpuri.
There is a provision for delay, condition of delay that was done.
Without any sufficient reason that has been condoned, without issuing any notice to the
But that was confirmed. If you challenge that order,
I have challenged that in the appeal manner, in the election appeal manner. My sole ground was there. The election petition ought to have been filed within 15 days as per section 31 of the Orissa Gram Panchayat Act.
but that was filed beyond, that is more than 4 months.
More than 4 months. And sufficient ground was not stated by the respondent number 1 while filing the limitation petition.
Where is the For conversation, where is the order conversation will be there.
That is reflected in the imping order
It is not required. Just show me that application.
in the writ petition. It is there, my lord. And you know,
Hey,
the writ petition it has come along with the writ appeal, my lord. I have not.
You will not have any those copies in the rate appeal.
That is at page 25 of the writ petition, my lord.
Lord, the thing is, Lord, the delay was condoned. Lord, that order was not challenged. Thereafter, the election petition was disposed of.
The whole crux of the entire.
In appeal also, they did not take that ground. Now, in the read petition, they are taking that delay ground.
In the appeal, I have taken the ground, whole ground, my lord. In the appeal, my lord. My place that my lord. Yes, sole ground of the.
Where is that appeal, sir? Everything you are arguing in here.
In the writ petition.
But you are not
here.
producing those documents.
The
I
writ-
am asking you
Yes, ma'am.
to produce me a application for condonation. You are asking. I said, where is the order condoning the delay? Not with you. Now he has taken a plea that you say that you have taken in the ground, produce the memo of appeal. How we will proceed?
In the restriction also, it is not there.
In the writ petition, judgments of the court.
You have not
My-
enclosed to the,
My
The-
above that, my lord.
the documents which my lord has just,
Yes, petition.
you are not, enclosed.
What to do, sir? How you will decide, we don't know.
Well, that is reflected in the improved documents of the courts below.
The court will decide on the basis of a judgment. If you are before the first appellate court, like that is fitted appeal. We are judging whether the judgment of the single bench is correct or not. On what basis?
It should be,
We will
I
say
will
that
try.
this was the document available to him. We have wrongly interpreted the document. He has not considered those documents something. We don't have a document.
my lord. I will file, my lord. I will.
What file? You did not file in the appeal. You did not file in the appeal. How you will file? How you will file those documents? Tell me.
By applying those, by applying to the court, the learned courts below.
What?
I will apply for the certified copies in the courts below.
Oh, certificate.
Because
No,
it-
how you will file in the appeal? For the document.
In the writ appeal, I have only enclosed the order of the honorable solicitor. Whereas in the writ petition, I have enclosed both the judgments of both the lower court.
The Crown Court has said that the London judge that you have not. That is what I am saying. In the writ petition, he has not included all the documents.
right?
That's my call for the retired from the trial court.
Then, please, then,
From the order, it's mine.
appeal.
Mine.
It's not there before the learning CBS. Like this history. Very powerful. It is, it's going to be.
You have not find anything, it's not there. We have gone through it, it's not there. Annexure 1 is the copy of the improved judgment. Annexure 2 is,
Copy of the appellate document.
and the copy of the improved judgment dated 30th November 2023 and 11th March 2024. Not more than that. These are the two editions.
From that annexure also, it is clearly crystal.
Sir, I am very surprised when such kinds of thinking is done. You are assailing a particular judgment on the ground that the condonation was not proper. Will you not annex the copy of the condonation application and the orders containing the delay? What are you saying now? You are approaching the court. These are the two vital documents to decide. Sorry, we don't find any wrong in that. Let's see what this is. What is this submission for? That's all. Sorry,
There is description, suspended description under second proviso to section 31.
Right. That is discussion is
And issue number 3, very elaborately here discussed as the convoluted.
really has not been fundamental. My humble submission is that really has not been properly explained by the respondent above. And in a similar case, my lord, this honorable court part order, my lord, the opportunity of hearing is most, my lord. Might be kindly for me, my lord. And please, para 6 and 7. In a similar case. My lord, my kindly say para 6 and 7. Relevant para my lord.
Very interesting fact is the said different of village due to reasons mentioned in the section the convention of delay was allowed to and a delay has been totally big unknown by the other patients being of this one. So the 12 or election that is over. That is never challenged
Right.
by you.
No, I don't never challenge. Only challenge in the appeal. Yes, well, I have challenged that in the appeal.
After participating
In the court.
thereafter, in the writ petition also, you have not taken that stand. And
In the writ
independently, you
petition, I
have
have-
not, independently, you have not challenged this order 3/8/2022. Can you at this stage?
In the appeal stage, I have challenged. Before the appeal.
Here.
Here also I have challenged, man. In the writ petition also. Yes, man.
Explain and go on. After final,
Any more? Today. Yes. Pays to the B, or this one, or judgment, that is the
the single main WPC number 6730. By
Item 19.
Item 19, my lords. May it please your lordship. My lords.
Yes.
Yes.
Non-adherence of section 54.
Non-adherence of section 54, my lords. My entire case is twofold, my lords. One is, my lords, the resolution which has been passed against the petition
Is unreasoned.
is without any reasons. I'll read out the resolution before your lordship. My second point, which has not, unfortunately, not been dealt by.
Does it require any reasons to be?
My lords, that is exactly the
Resolution is not. Is a resolution taken by the majority or a requisite numbers of members
Yes, my lords.
or no confidence.
Yes, my lords. Now,
So now, there is no grounds is required to be assigned or something.
as I, my lords, my lords, this honorable court, a single judge of this honorable court in a previous decision, that is the Kantik Kumar, plus again, my lords, it has been upheld, same judgment in Sulochana Behra, on which the learned single judge has relied upon. We relied upon a judgment, a division bench writ appeal judgment of the Patna High Court, which says that even if you have the sheer number,
Which has a more binding precedent, the judgment of the same court or a judgment of a.
my lords, that is a single judge's judgment, my lords. That is why I'm arguing before your lordships. A division bench, my lords, your lordships will consider the Patna High Court judgment, which has decided in a writ appeal that if you just have the majority and you just have the brute force, then it is not enough to bring about no confidence resolution against a person, particularly when.
That is in relation to a different.
Panchayat Act, my lords. We are
Every state has a
as a Panchayat Act, my
Differently
lords.
worded. Differently worded.
Yes, my lords. So, my lords,
Is,
I'm just placing those judgments. It's for your lordship's considerations. My lords, they say, I'm just placing a relevant portion of the judgment, my lord. When I'm just placing the relevant portion, my lords. Para 7. This, my lords, of course, I do not have the. This was preferred, an appeal was preferred against this to the Supreme Court, which has been dismissed, my lords. Thus, the record to bring in an action for a motion, the lordship gets paragraph 7, for no confidence against a pramukh and elected officers on record. On record, there is not a shred nor a whisper of what is the wrong done by the pramukh and what exactly he is up against when he will face an opportunity to reply as to why he should not be bundled out of his office. The court is afraid that it does not agree with the counsel for the appellants that majority is a democracy. If this be so, would it not be mobocracy? After all, democracy functions on sanctions of law. Democratic institutions follow, respect and protect the rule of law. Otherwise, majority is not democracy but anarchy. Brute majority cannot be little democratic institutions. Such bad practices lend themselves to dictatorship. This is an angle, this is an example which reflects the evils of having lost 30 years of experience on self-government. Even the basic norms of democracy and institutions of self-government have been forgotten. Coming down now to realities and the concept under such a motion of no confidence motion may be considered. This is what the, my lords. This is under the Bihar Panchayat Raj Act, my lords, 1993. This is like under a latest patent appeal, my lords.
Have you read paragraphs 9 and 10?
Yes, first. I've read that.
So there is a express provision in the statute that you must specify the reason or the object of calling the meeting.
Yes, sir.
That shows that the ground of misconduct or whatever of the nature has to be reflected. That was there.
Yes,
Does
sir.
it appear the same provision?
This provision is, my lords, absent here.
So how
But
can-
my submission,
Why?
my lords, my submission before your lordship is the when we read the principles of natural justice into an act, my
You
lords.
wanted to say everything is ingrained and engineered into the provision. Something which is conspicuously absent must be deemed to have been
Taken away, my lords.
Yes,
My lords, but here, my lords, when we are dealing with the principles of natural justice, fairness demands that when she
Fairness
replies,
that you should be given an adequate opportunity to defend.
yes,
When a no confidence motion is taken out against you,
my lord.
then in that event you must be given an opportunity. Only thing is that I have lost the confidence on you.
My lord.
The question is that if the majority does not want you,
My lord.
then you should always respect the decision of a majority.
My lords, my humble submission before your lordship is, my lords, a meeting is called for a debate on whatever irregularities I might have committed, my lords. Now, there I have to face my voters. If I am to face the voters are the elected council members. Now, if I am to face the my lords, I need to know what has been alleged against me. They simply say that we are not satisfied with your performance. That if you are not satisfied, how you are not satisfied with my performance? Let's say I have, my lords, misappropriated money, or I have not done the work as per your specifications. Nothing of that extent. We are not satisfied with your performance. And they throw me out.
What is the requirement of the
The Act says, my lord, there are two. This is my first round. The second round is also there. 54. Lordships, 54-1. Where a meeting of the municipality specially convened by the district magistrate in that behalf a resolution is passed, supported by not less than 2/3 of the total number of councillors.
Where is the judgment of this court against you?
Well, this is the first judgment. Your lordships may kindly turn to page 6. Paragraph 6, where they have relied on an earlier judgment of this honorable court.
I have already read.
Yes, what?
So in that event, what to do?
My lords,
That's the consistent view of this court.
yes, my lords. By single judges, my lords.
This is what is distinguishable on fact because those specific expressions are absent.
My lords, here what I am trying to urge before your lordship is,
This is
my lords, predecessors is there, my lords. I'm not saying no, my lords. In fact, there also we had said, yes, these are judgments against us, but there are judgments also in our favor, my lords, which,
of our.
no, not of our High Court, my lords,
So
we do not.
why we will travel to other high court when we have our
My lords, there is another judgment. Of course, I've not got it.
view.
I've not got it here, my lords. There, my lords, the chairman against whom the no confidence motion was being moved, there was no necessity under the act to serve. That is the Municipality Act.
Simply say recording point of contact. The motion is there, ultimately, the majority comes. Go and face the democratic.
No, we have faced it, my lords. We have already been removed. So the thing is, my lords, whether without any reasons can I be removed? That is one question. And the second point that I'm urging before your lordship. Admittedly, no notice was served on the chairman. Now, if your lordship kindly sees,
As the chairman of our lord.
no, I am saying that the chairman, a notice has to be served on the chairman. Otherwise, the entire process is also vitiated because he also has a vote.
As the chairman says that the notice is not served on us.
My lords, I have avoided and they have not denied this. No, chairman has not come.
So chairman was there in the meeting.
My lords,
Chairman was there in the meeting.
he was that.
He was there in the
We
meeting.
are not aware, my lords, actually. Because
Has to be. Chairman will not be there in the meeting. It is improbable.
my lords, I'm not, because the counsel who was assisting me, my lords, unfortunately met with an accident. So anyway, my lords, this is the.
Has to be there. If he has not said that the something has not been affected already, not happening.
These are my two main points.
We go by our judgment, our High Court judgment as well.
My lords. Well, I'll just show your lordships.
Yes,
My lords, I'll just show another judgment of this honorable court.
absentee,
Smita Rani Mahanti.
absentee.
No, not an absentee. What I'm trying to urge before your lordship is,
What is this?
this, my lords, relates to
No, chairman, you said.
the chairman of the my lords municipality. Here,
What, absentee or what?
no, my lords, my point there is no absentee. No, the chairman was the chairman. She was removed by notice was not served on her, and she was no confidence motion was moved against her. This was challenged by her before this honorable court.
This is this matter.
No, not this matter. This relates to another matter the law laid down now.
Sorry, I am talking about.
No. Here, my lords, as per my instructions, the chairman was absent in the meeting. I'll take your lordships to section 8. Here, my lords, why I'm placing this judgment is, my lords, there, no provision is there under the Municipality Act that a year should be served. Notice of no confidence is to be served upon the chairman. But this honorable court held that even though the act does not contemplate of such a notice being served on the chairman, however, the principles of natural justice demand when the action is going to be taken against the chairman, that she should be given a notice of the proposed action which is going to be taken against her. So, my lords, that is what I am trying
There
to.
is a proposed action of removal.
A proposed action of removal, my lords.
So
Now, the
that is
proposed action of.
You are communicated.
My lords, what I am trying to urge before your
The ground
lordship
is that you should be given a ground specific, like a disciplinary proceeding, that what charges you have to.
My lords, exactly. Otherwise, my lords, it becomes an empty.
Section 1 is silent.
Otherwise, it becomes an empty formality, my lords.
It's not an empty formality.
My lords,
An opportunity to defend yourself there.
my lords, I don't know what are the charges against me. So how do I defend myself?
Only no confidence.
My lords,
There are two ways of removal. Sir, there is a way of removal is section 53 is a different, where everything you have to be given.
yes, my lords.
And 54 is a different standalone provision.
Standalone provision.
It
my lords.
says simply no confidence, nothing more than that.
My lords, no confidence.
Even there may not be any ground, but I have lost my confidence on you.
My
That's
lords,
my own perception. I do not want you to.
that is exactly what the Patna High Court
By
says.
virtue
You
of
can't do.
majority, I want.
No, my lords, that is exactly what the Patna High Court says. No,
No,
you can't do it.
There was a different provision.
No, there is a different provision.
It says the opportunity of hearing in subsection 4 therein of section 44.
And you have to
And
give the
misconduct
specific
and-
charges.
And the demeanor misdemeanor, where the grounds,
Yes, my lords.
and then subsection 3 says specify that reasons.
Specify the reasons.
But here it is absent.
My lords,
There are two different provisions.
no, I understand, my lords. What I'm trying to
53, definitely you are entitled to all the, the intricacies of those charges.
yes, my lords.
Because 53 is very clear.
My lord.
It says that chairman or a vice chairman can be removed if they have willfully omits and refuse to carry out, disobeys the provision, rules, bylaws, regulations, lawful orders.
They may cause an inquiry.
And then inquiry needs to be made.
My lord.
On receipt, opportunity to the chairman or vice chairman will be given.
Exactly.
And then thereafter it will be taken.
54 is a standalone provision, but my lords, in this standalone provision, my argument is, my lords, if your lordship, it's my duty to argue, my lords.
Okay. That's fine. Yes.
And section 8, my lords.
Section
8. Every municipality shall be composed of a chairperson.
Composition of the municipality and
Yes.
participation right in the meeting.
Yes, my lords. My lords, a chairperson directly elected by the electors of the municipal area, one councillor elected directly from every ward within the municipal area, a person having, provided that the councillors so nominated shall not have the right to vote at any meeting of the municipality, but shall have the right to attend every meeting thereof, except the meetings convened under section 47, 49 and 54. This is a meeting convened under section 54.
Year of concern.
So, my lords, the chairman has a right to vote under section 54. So he's also entitled to a notice. That is a procedural error.
But he has not come forward and challenged this.
No, he has not come forward. We are saying that this is a
So
procedural
what
error.
to do?
My lords, and they have to pass a resolution. So that has to be actuated with reasons. And reasons will only come forward flow when I can properly defend myself. That is my argument for your lordships.
Yes. There is a judgment of 2007 ONR.
Yes, my lord. Obliged.
Item number 20.
Item 20 will I seek the copy of the appeal law. I taking consent from my senior and I need some time.
Next week, you need to line.
Leave there out.
First week of the.
30th. Last week, 6th. Item 21.
In this matter, last occasion, that leads to grant us some time to file writ appeal, challenging the same order. If my lord is similarly challenging, you know, today we are filing the writ appeal. Take up next week.
And the supporting may cause nuts. In fact, that's it.
Next. Don't for the week of the press.
Item 22.
On the other senior supporting next week. It is to the next week. After the next 2 weeks.
Item 23.
Please, Your Lordship, I'm appearing for the respondent in the matter.
Order under Annexure 1. Faster the Annexure in the
Yes.
All supported. Yes, we found out. Yes.
Will the earlier order passed it a appeal or the
It pays 123 of the writ petition, Annexure 14.
Yes. Annexure
14,
page
123 of the writ petition. Order dated 22nd April 2022 by the Honorable Single Judge.
I do not have 126.
Writ petition.
I'm talking of both. You have not annexed.
The previous article, the annexed in the writ.
Was that question that it is a work contract and therefore not coming under the possible the MSME taking in that particular
In that round of litigation, it has never been taken.
No, that petition was filed by the other side.
Exactly. That has never been taken throughout that course of litigation, right up to the review. That has not been taken. So, my lord, after failing therein, they now have gone before the arbitrator, filed an application under Section 16, saying that go through the terms and conditions of the contract, the conduct of the party, and see that it's a worse contract. You don't have any jurisdiction.
Your contention is that they should take recourse to arbitration with consideration at section 34, not the rate.
Exactly. It's an order arising out of section 16 of the Arbitration Act. My lord. Because during the continuance of the arbitration proceeding, my lord, before the MSME council, they have filed an application under section 16 of the Arbitration Act saying that the arbitrator has no jurisdiction to, my lord, entertain this matter since it's a works contract which is evident from the terms and conditions of the contract. My lord. That having been rejected, section 16(5) provides that if the application under section 16 is rejected, holding that the arbitrator has jurisdiction, then the party has to wait till the passing of the hour is passed so that he can raise the decision in the 34 applications. Now here, my lord, will approach this honorable court saying that, my lord, again for evaluating all the terms and conditions of the contract.
Where is the provision under the MSME here?
My lord,
Regarding the applicability of the
section 18. My lord. If the lordship would turn to 18(4), where the mediation initiated under subsection 3 is not successful and stands terminated, which has happened in this case, without any settlement between the parties, the council shall either take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of the Arbitration and Conciliation Act shall then apply to the dispute as if the arbitration was in pursuance of an arbitration agreement referred to in subsection section 7(1) of the Act.
yes. So it is in section 34 is the proper remedy. I believe there is a state judgment in the Sunday that there is one judgment this bench has deprecated it.
Yes, ma'am. Here the issue was section 16 application saying that whether the agreement, the arbitration agreement should suffer stamp or not. Again, evaluation of the terms and conditions, and this honorable court held, referring to Bhavan International, that evaluation of the terms and conditions to determine whether it requires stamp or not, and in like case, whether it's a works contract or not.
Which for the other side?
I am appearing for the respondent, your lordship.
What do you have to say? We have taken a decision. What do you have to say? And the same decision was taken by the secretary. We set aside the order, and then had they gone there with the Supreme Court against that?
Yes, in fact, your lordship, your lordship is referring to the IOCL matter. They have gone. Sir, let me just complete. Yes, in the Indian oil judgment, your lordship, firstly, they have gone to the Supreme Court. Also, your lordship, the reasons for which that judgment was set aside are completely different. That was a matter in execution, and your lordship had held in that the objection.
In fact, referring to another judgment. In fact, I have given a new.
No, he is relying on the Sunflag Iron and Steel Company versus Tadini Prashad Mohanty judgment.
Yes. In Sunflag,
we have said that under what circumstances we will encourage this.
Your lordship, my case is slightly different from Sunflag. In fact, Sunflag also notes that exception when a writ can be entertained against a section 16 order. In Sunflag also, your lordship, I'll just point out that one paragraph where it says that a writ may be entertained against an order under 16 if the tribunal lacks inherent jurisdiction. So a distinction has been drawn between mere lack of jurisdiction and inherent lack of jurisdiction. My case before the learned single judge was also inherent lack of jurisdiction. In fact, your lordship, in the Sunflag judgment, paragraph 18, that distinction has been noted by your lordship.
That's true, but contract and order of contract and everything. Why not you save this before 34?
Arbitration proceeding is still pending, but they've also filed after this order, the 16 order, they filed their defense. Because the arbitrator, that proceeding is pending. And it has been passed by the Honorable Single Judge.
We had filed our defense on a without prejudice basis, your lordship. If your lordship can simply have the Sunflag judgment of your lordship, paragraph 18, that distinction has been drawn between jurisdiction.
I have read it.
Yes.
But that was in a different concept. Yes.
See,
I think in Sunflag also, the same line of judgment, same thing was applied.
that is taken. Yes.
What is the stage of the SLP there? In
Your
Sunflag,
Lordship,
After SLP has been admitted, no stay has been granted. No stay is there, but SLP has been admitted and notified to the commission. It was pending as their last statement. No final decision. Here is the case, my lord, after they have, my lord, become unsuccessful in the first round of litigation where they have never raised this issue.
I'm sorry, please do not make incorrect submissions. I have raised this issue at the very outset in a section 16. There can't be a stage earlier than that.
Section 16 was filed
prior to my statement of defense. And your lordship, Sunflag's judgment, if your lordship sees paragraph 3, the issue was completely different. It was the issue of stamp duty. What I am saying
we
here,
are concerned, we are conscious where what we have there. That is, I can share that I authored the judgment, so I know what was there and what was there. So there the question was that whether the writ jurisdiction should be exercised so casually that every aspect has to be gone into there. So I have read two things. One is that though there is no absolute bar in view of that, but still the court should decline to interfere or entertain it. The second issue I say is that once the interpretation of a contract is involved, then it is the arbitral tribunal who is the final authority interpreting the nature of the agreement. If the arbitrator has found that it does not attract this stamp duty, then in that event, that has to be taken as a final. And in view of the provision of the Act, they can challenge that by virtue in a section 34 under section 34 against the award.
your lordship, yes, your lordship is right. However, and your lordship has rightly said, if there is an issue of interpretation of the contract. However, your lordship, we are not on the interpretation of the contract here.
The question is that whether it is a work contract or it is not a work contract. The nomenclature or the nature of the contract is the main question. Whether that can be gone into.
Your lordship, that is what my submission. If it's ex facie, the nature of the contracts involves elements of supply and service.
Can you go against the mandate of the arbitrator? It is so shocking to your conscience that no reasonable man would be able to say that this is not a work contract.
No, your lordship.
What troubles me? What do you say? You have to.
In the Sunflag, this one, Honorable Supreme Court has permitted the arbitration proceeding to go on, but it will not be finalized without the leave of this court. That was not stay in this. Right. The Bhavan International case, which your lordship has referred to in that judgment, exactly that was the question, whether it's a works contract or not. If it is a works contract, then the Gujarat State Act will apply. If not, that will not apply. That was the question which Honorable Supreme Court has said, no, it involves going to the nature, terms and conditions of the contract, which the writ code should not interfere. Should not interfere in that. That was the decision in Bhavan International case. Writ code in Article 226 will not evaluate the terms and conditions.
No, that is what.
So that the question was whether it's a works contract or not involved in that Bhavan International case. That is the case.
If the arbitration concludes, then what will happen?
Party they can file a 34 application, and if I lose, I will file a 34 application.
Your lordship, in fact, now there is some authority. Your lordship, there is some authority also now to say that if there is inherent lack of jurisdiction, even a writ would be maintainable against the final award. So, Your Lordship, in fact, this issue, if I must point out, this issue was the first decided. One of the earlier judgments was Bombay High Court in PL Atke. That issue was challenged the Supreme Court and SLP was filed. Very recently, in February of 26, Your Lordship, in fact, leave has been granted in that matter, and the matter is now listed for arguments in August. If Your Lordship may, in fact, consider. My colleague is carrying a copy of the Supreme Court's order in PL Atke. It's the identical issue whether MSME can decide a works contract or not. Your Lordship may postpone it until August. Let the Supreme Court authoritatively decide. Because Your Lordship, in fact, that multiple high courts have taken a similar view, including Delhi, Bombay, Telangana. Your Lordship, Your Lordship may just see the order of the Supreme Court in PL Atke. Paragraph 19, 22, 32 of PL Atke. In fact, that is also the basis for the.
When is of how much? What is the composition of Bhaven?
Pardon me, Your Lordship.
I have relied upon the Bhaven judge.
Three judge.
Three judge.
Three judge. Three judge.
I distinctly recollect. That's why I asked this.
So also to see paragraph 25.
Yes, which is binding, the two judge bench decision or a three judge bench decision of the Supreme Court? Tell me, sir.
Which is binding on us, the two judge bench or a three judge bench?
Three judge bench, of course, Your Lordship.
So, Bhaven is the same thing which is there. It says the work contract, it requires evidence, it requires many things to be gone into. So at this stage, it should not be.
Your Lordship may just see one judgment. My colleague is carrying again, it's a three judge bench. Punjab State Power Corporation versus MTA Coal. And that also, in fact, draws the distinction very clearly. Can I request my colleague to pass the judgment? MTA Coal.
Tell me who is your colleague, sir?
Mr. Behra.
Where is he?
Mr. Behra, can you please hand over the judgment of Punjab State Corporation?
Paragraph 14 of your Lordship judgment refer to this Punjab.
So, Your Lordship, this is also three judge bench.
Yes.
It was a challenge to a section 16 order.
15 is a different.
Paragraph 4, Your Lordship, is where they draw an exception.
So who says if the order passed is so perverse that it only possible conclusion that it is a patent lack of the inherent jurisdiction? If that being the position, then there is no difficulty. If the work contract, if it is a work contract, not a work contract, as Bhaven says that it requires an evidence to be taken and everything is to be gone into, then why?
But your lordship, to determine whether it's a work contract or not, that's really not a disputed question of fact or law. It's merely we have to see the nature of the contract if it involves elements.
Sir, what are you talking? Nomenclature will decide the contract.
No, your lordship.
Nature of the contract.
Your lordship.
Or it is how the parties have perceived, how they have acted upon, and then the different clauses of the contract has to be gone into in order to ascertain.
Your lordship, with due respect, if your lordship can just have the scope of work, I think the scope of work is which is undisputed. If the scope of work from the mere reading of the scope of work, it can be determined whether it's a works contract.
I do not know then why Bhaven, this three judgment says that it requires the paragraph 25, it is clearly said.
Your lordship, I can understand.
It says there is a pertinent question, therefore, is whether the present contract, which is a composite in nature, falls within the ambit of the work contract under section 2K of the Gujarat Act. This is a question that requires contractual interpretation and is a matter of evidence, especially when both sides have taken contradictory stand. They have said that it's not a contract. So this is what Bhaven has said. And the Punjab state power has not said anything on this aspect.
No, I understand your lordship.
Sorry.
But
So that is why we say is a work contract. No,
your lordship, on the facts of Bhaven, I'll have to see the facts, your lordship. That judgment was not particularly available right now.
What are the Bhaven I have read?
Your lordship,
paragraph 25 is a work contract.
Your lordship,
and whether it comes within the work contract or not was a question involved there in Bhaven.
Your lordship, I wasn't supplied with that judgment prior to the hearing. Your lordship may then allow me a week. I'll file my response also, and I'll come before your lordship physically.
No, sir. I never heard of, sir, that a judgment has to be given in advance to both of you to the other side so that he will come. I have never come across.
No.
It is cited at the bar. You should be ready with all. You should be ready with all possible points which they are taking. And they are relying on a judgment.
Yeah,
if you do not do the judgment, then what? You are aware of sun flag. In a sun flag, the Bhaven has been considered so clearly. You have not read the Bhaven.
No, your lordship may just give me one date since I'm appearing. So
what is this? This is not
to appear
when a bench wanted to, when the bench put lot of questions, then again you started.
No,
and in a Bhaven, it has already been referred in the pleading as well. I could get at page 20 of the writ appeal. They have said. They have relied upon Bhaven at page 20 of the writ appeal. You have not read it.
Your lordship may only allow me to come physically, your lordship, and assist your lordship.
Sorry, this is the way to encourage the adjournment.
Your lordship may dehost that. Your lordship may only consider my argument that if I can fall under the head of patent lack of inherent jurisdiction, because we are only on the interpretation of the statute. If the statute does not permit a works contract, then ex facie, if the contract says that this is a contract for supply as well as services, your lordship, going through an entire trial will be a futile exercise if the only ground that I've raised today is a legal ground. That proceedings under the
We will be deciding only on a legal ground. We are not going to decide on a basis of fact. Not
so, your lordship. That is what I was submitting. That all that I'm saying is that because ex facie, your lordship will see the scope of work. It involves element of supply as well as services. There is no disputed interpretation on the scope of work of the contract. All I'm saying today is, your lordship, the MSME is very specific it refers to purely supply contracts, purely service contracts. That is also the intention of the legislature. For more simple contracts, let there be an MSME council which awards exorbitant interest at 36% compounded monthly, but that is not the intention when it comes to construction contracts. And that is what even the Supreme Court in Coney Elevator has specifically said, that a works contract constitutes a third category of contracts. So there's a supply, there's a service, and there's a works contract. So you can't today say that because a supply or a service contract cannot be equated with a works contract. So my only submission, Your Lordship, is if today looking at the scope of work, it can be on the face of it, it can be said that this is a works contract. Therefore, Your Lordship, me going to the company, going through the entire process of arbitration and then eventually challenging it, Your Lordship, that exercise may be saved because, and which is also my submission, that if my case can fall under patent lack of inherent jurisdiction, then Your Lordship may consider my case. That is my only argument.
That's all. We'll consider. Yes, keep it for orders on the next. This one, and send it to me immediately with the book. MSME. Yes.
For orders, item number 24.
Your Lordship, may I be permitted to file written submissions?
No. We will consider all your judgment. You have already cited.
Very well, Your Lordship.
Hearing for respondent one and two. And for respondent one, 3, Your Lordship.
Appellant.
The hearing in person.
In person manner.
None appears in support of the appeal. Let the appeal be listed. Last week of April.
Last week of April.
Item 25.
Issue minor, but he is claiming whatever claim he has made.
Oh, now he has come.
Sorry. 2686.
Not revealed. is all Supreme Court.
My lord, page 1.
Counter media and Annexure 6, page 29.
This one.
Computer based access software.
This one. Just. कीबोर्ड काम बसते 470 बेस्ट अरे एठी काही काम करूनी कीबोर्ड खोलते जाई बट एठी काही काम करू खोला दे यार काम लोग बोलना एठी काही सोचो वाई पे नहीं सर
So why he has filed the application in the writ appeal? Why not?
My lord, as per the Honorable Supreme Court order,
Supreme Court order is very clear and does not read, not clear. I mean, we have interpreted in a different manner. You filed a writ petition claiming the various reliefs, including the interest on the delayed disbursement of terminal benefits.
yes, my lord.
Correct? The single bills did not allow this.
No.
You filed a review.
Yes.
interest and compensation both. Then you challenge the parent order disposing of the writ. The court did not interfere with the order. Then you went to the Supreme Court. The Supreme Court did not set aside the order of the single bench or a division bench. Both did not. Simply, a liberty was granted to you to approach the High Court in a disposed of matter and make an application, claim this. Now, once the High Court or a disposed of matter is used, does it not mean that you have to approach the single bench? Because the matter is disposed of by them, by the single bench. Appeal could simply affirm the order of the single bench.
My lord, as I am not a professional lawyer, but I have been suffering since last 11 years, my lord. I have lost my family. I am the last surviving member of my family. So here this honorable court can give the justice, and it will further delay the matter, which will obviously affect my overall condition, and I am already suffering.
No, we are not directing you to make an application of raise. Only thing we are thinking of remitting the matter to the single bench to treat this application to have been filed there.
My lord, it will further delay the matter.
What will further delay?
My lord, already this matter has been considered by this honorable court during the last order is there.
The Supreme Court has not permitted him to go for a compensation. Only the interest, delayed interest.
This part. So singleton had this, and singleton says.
When he died,
My lord, 27th May 2015.
and when the CMPF amount was given,
They have not given the CMPF amount. It is still they have withheld the CMPF amount. And they are not also disclosing the details of the amount like after the death of the employee.
who is the Mahanadi Coalfield Limited? What you are not doing is, he served, will you not give him the CMPF?
According to the rules, if the amount exceeds 10,000, so you need to give a succession certificate minutes.
What?
Succession certificate minutes.
What succession certificate?
That is the son of the.
Where is the rule?
Where is that? In single bench, I think I have dealt with one matter saying that legal heir certificate would suffice, not the succession certificate. There is requirement. Yes, I have. Perhaps in another case.
Yes.
In another case, Mr. Devraj was appearing for MCL.
Gratuity is paid?
My lord, it is delayed after my mother's death. First, my father died on 27th May. Then my mother.
Don't go, we understand. We are asking you a simple question. Gratuity has been paid?
After delay of 1.5 years after PM agreement.
Whatever. I am asking you very simple.
Yes, my lord.
Paid.
Yes, my lord.
But there was a delay.
1.5 years.
Paid to your mother or to directly?
To expired, then they.
Paid it to your mother or to you?
Me. And without any interest.
Oh, understood.
We are filing objection in respect to the coal mines provident fund scheme. On that, basing on that scheme, instead of fighting the cases here, last occasion also I am suggesting that simply it may take 6 months or some to getting after notification of these things, suspending certificate. If you approve the civil code and get the certificate, nobody is there. According to you,
was that where is the requirement?
This is a scheme at page 70, annexure 7, page 31. That's may come to 11 page, 33. Yes, I'm just passing this.
Requirement of petition,
I'm just passing.
succession certificate. And he is the last successor.
That's easily he can get it.
Not easily, sir. Not easily. Not that simple as you say.
Legal hair certificate.
Do you know how much amount he has to incur? Are you aware? Once he goes and make an application that the succession certificate should be issued in my name.
Yes.
First thing is he has to disclose the quantum of the contributory, the provident fund, as well as the gratuity, which you will give after 6 months or 1 year.
We have
Secondly, the moment he claims that I am the only surviving successor, then there will be a notification, there will be a publication in the official, any of the newspaper. How much does it cost?
For submitting application, there no need to submit the court fee in respect to the amount in succession certificate. Succession application will be filed with the civil court, praying therein that.
So to whom you are saying all these things?
I am not educating my lord. Because in Odisha, what's
under the Indian Succession Act, there are procedures.
Yes.
That they have to make an application. Now, so far as the Court Fee Act is concerned, it differs from a state to a state.
Yes.
It all differs. Some state says that you will have to pay a court fee according to the value. Some says that the fixed court fee means either ad valorem or fixed. It all depends. I do not know in Odisha whether it is a fixed court fee or it is an ad valorem. You have to pay. Secondly, the moment he claims, he is declaring by way of an affidavit, the court will not believe, will direct the publication to be made in the newspaper.
My lord,
How much it will cost?
My lord, it will not much cost because
sometimes the entire amount is consumed there.
No, man.
Like letters, you do not know how much they charge.
No. I don't know what their notification coming to the collectorate.
No, it's not a notification.
Good because then nobody is there. 2017 onwards, we are writing such letters. If you nowadays, good person lagu succession certificate no. Time lagte legal area 1 month re miliboni seta.
Who was a nominee in that? Now the question of nominee was also there. Who is a nominee in that?
The mother was the nominee. Mother was the nominee.
She also died. This is the whole problem now.
The whole problem is created by you. When the mother is alive for a pretty long time.
When you are aware that he is the only sole survivor in his family, then
if this amount will more than 10,000, then we will.
Is there only one single nomination or it's a double nomination?
Single. Lordship will remand back to single judge with this observation, or my lord may pass order executing that there no need for succession certificate. Then I will advise this coal mine scheme to attend getting this certificate. Only these two alternatives here. Otherwise,
What to do?
we can override this
Succession. Not be resolved by your intervention. What are you doing? A gentleman is knocking the door since long.
Repeated what I asked that officers. I'm telling you correct man.
it is only scheme, no?
Yes, it is only scheme.
A scheme.
What is
Because the coal mine is a separate scheme. basing on which you have to
Is
pay.
whether in the Provident Fund Act there is any provision?
That's where there is a.
You are governed by the Provident Fund.
CPF Act, there is a extent scheme. There is no rules. So you have to act on the scheme only. So the scheme says that.
So you will forget the act.
No.
You can't forget the act.
Anything about the payment. Act is what if default, then what is the interest, how it will proceed, seminal proceeding will proceed against the authority concerned, those who have not deducted amount. Act says all these things. But scheme says how to settle the issue.
Yes, sir.
No, just tell me, in the writ petition, what was the relief which was granted to you?
My lord, only the withheld amount, go and claim that amount, and that is without any interest and without any
No.
compensation.
Where is the judgment? Let us see.
Page 23 for objection affidavit.
We are just trying to do something because page.
My lord, the
Objection affidavit of mine.
Where is the
Next
judgment?
one, page-
Where is the judgment of the trial court? I mean the single bench. In a writ. That is a 13-9 or something, what we would say.
Page 21 of my counter. Page 21. We have annexed it. It is the order dated 12/9/2023.
Computer page for writ petition.
my lord, 26 page
ঠিক আছে
of the ID.
আমার ওই অবজেকশনটা হচ্ছে পেজ 127 ফ্ল্যাগ জেড টু জানতে
Just 6 number computer page for this.
Proceedings and regulation.
The paragraph 5 of
Just,
writ petition.
No, that is what I was thinking. The declaration is cut. I was just trying to go into that.
Okay.
I know, for that reason I asked. Now, sir, what is the purpose of the succession certificate?
only to work on the scheme man.
No. What is the purpose? Why the Indian Succession Act introduced the provision relating to succession certificate?
Only to know these
No, is only that who is entitled to a movable assets of the deceased and is entitled to deal with those movable assets, not immovable. It's only the movable assets. So it is a recognition of a right of a person to deal with the movable assets of a deceased, which constitute the state. That's the only thing. If in a judicial order, the court has said that he is the only heir, he is entitled to all the benefits, why you will insist for a succession certificate? If a high court has declared his status, then why a district court will issue a succession certificate and high court's observation will not be considered?
Because they have not challenged this or why?
But para 6 is something you
Please read paragraph 5 of the Now, I'm reading. As per the copy of the legal heir certificate enclosed to the writ petition, it is seen that the petitioner, being the only son of his parent, is the sole surviving legal heir and is therefore entitled, prima facie entitled to receive all terminal benefits. That is what is here. Then you say about the succession certificate. Then 6. Considering the submissions as above, and without expressing any opinion, this court deems it proper to dispose of the writ petition, directing the opposite parties' authorities, particularly to take all necessary steps for release of the admissible term benefit of the deceased in favor of the petitioner. What does it mean?
Manoj, that's why you are not.
You did not challenge. Nobody challenged except him.
Manoj, we are not refusing to pay. We are only submission we are submitting there.
So Indian Succession Act.
Giving the succession certificate.
Indian Succession Act.
Because of this order.
Because that's why, my lord, what I'm saying, this my lord is single judge.
You are not challenging this order. This order stays at you.
That's it. That's why considering the submission as above without expressing an opinion on the merit of this.
No.
Sir, please read observation. What the direction is.
Sir, he is the only son of his parents.
That's what he is observation.
He is the surviving legal heir. He is therefore prima facie entitled to receive all terminal benefits.
And then paragraph 6 it says, the writ petition directing the opposite parties to take all necessary steps for release of the admissible terminal dues of the deceased employee in favor of the petitioner. This is what troubles. Why? In favor of the legal heirs or heirs. I could have understood why the court says petitioner, not others.
Legal heir certificate as substitute of succession certificate. That is also there.
My lord, what I'm saying, my lord, the scheme what we have annexed with this, it is 71, 76.
No, sir. Scheme is to get an immunity to officers in case of a disbursement of a monetary benefits. Because it involves a monetary aspect, so the remittance has to be done in a particular manner so that he is immune from being prosecuted subsequently if third party comes and claims any right. Then that's why I say you will bring the succession certificate. So on that basis, ball is in the court of the district judge. But here, if there is a complete observation of the High Court, what more?
That clarification pass order we can
No, sir.
Because this only scheme is creating order. So
You have to come to page 35 of the petition.
35.
Have you taken any stand in your counter affidavit denying this document?
It was, I don't think it was counted in fact in the past day it was disposed.
No, that is a legal heir certificate. That is.
No other. Yes, counter kind of.
You see, the MCL is appearing. We are not appearing. And this is because we are not noticed, we are not appearing. There is information that MCL will pay, that's why they might have mentioned.
Have you taken any stand in the counter affidavit to dispute and deny the summons of 6?
No, we are not disputed. Rather, we are
over. That's all. That's all.
We have written the
when mother accepts that she has no other, only one, because in the legal heir certificate, mother's name is there, son's name is there. That means mother is aware that she has no other. So he is the only, mother now expired. Father is dead. Then
Who is entitled? He is the only person entitled.
Yes.
So. Taking a technical stand.
That's why on 2017, 2022, all were written letters to the different authorities.
I was looking at it.
Yes.
Please read the purpose, section 374 of the Indian Succession. What does succession certificate mean? Empower to collect. And if what it says,
But
what is the right is created? What for the right is created under the succession certificate? 374. Read.
Yes.
Yes.
Contents of the certificate.
Yes. Please read.
When the discharge grants a certificate, he said, therein specify the debts and securities set forth in the application for the certificate and may thereby empower the person to whom the certificate is granted.
What is this empowerment of a person to have those amounts paid in his favor? If by a High Court order, empowerment means the right to receive is declared, then does it not empower him to receive? This is a debt. This is a security. Both debt they owe as a debt to the deceased. You owe as a debt to the deceased.
They're coming under the category A and B.
Absolutely. Why not? Certificate simply empowering the person in whose favor certificate to receive all those money. And once the High Court has declared that he is entitled, then why he will not pay?
That is same as for 2071. Nowadays,
Pay whatever.
Have to pay.
Along with interest.
It is only the interest on the delayed payment of gratuity and Gratuity Act. It is to be paid immediately, 1.5 years or whatever be the amount. The direction to pay this this Provident Fund amount, and with an interest from the date.
My lord, last page, I am given a calculation. Our side,
Nothing more than that.
Yes.
My lord, there is honorable Supreme Court judgment is there. That is I would like to say the judgment. If where the delayed payment, in case of the delayed payment, there is penal interest and there are also compensation for that. And 18%.
Supreme Court, while remitting the matter or permitting you to make an application, did not refer the word compensation.
My the interest is there, my lord.
Only he says that you can ask for an interest. So we will be granting an interest on these two components.
My lord, kindly see this.
Look at the order of the Supreme Court. You could have asked the Supreme Court that I should also be making an application for compensation there.
My lord, I asked the honorable Supreme Court.
But the Supreme Court did not.
But they didn't mention, but the second fact.
That means what? If it is Supreme Court did not mention and only say you go make an application in a disposed of matter for interest, then we will be only considering the interest.
My lord, if it was only for the interest, then they could have fixed the interest there only. Why?
No, sir. No, sir. That we don't.
Kindly consider
Sorry,
judgment.
we can't.
My lord, in case of Vijay Malhotra and state of UP,
The compensation can also be granted by way of some amount, but here is a special case because we are dealing in a disposed of matter on a basis of the High Court, Supreme Court order.
My lord, the interest has to be 18% compounded interest in as per the judgments.
It, whatever be the interest statutory, what is there?
Statutory is 7.6%. We have calculated the same, and up to June 2025, that file counter, it is coming 36 lakhs 20,082. But again, we will calculate up to till date of payment. Because in Provident Fund Act, there is a specific interest which is defined by the Government of India time to time.
Whatever is the statutory interest which is provided, you will have to.
My lord, it is not a normal payment, it's a delayed payment after 2 days. So 7% is nothing as compared to this 2026 as the suffering.
If the statute of the Provident Fund says 7%, then can you claim any?
My lord,
We will be granting, you have the remedy, you can go, Article 142 is there. I think you take care of that.
my lord,
We will be going by a statutory rate of interest.
my lord, they have delayed for 11 years, 2 days.
So you are entitled to an interest. Where is the difficulty, sir? For 11 years, you will be paid the interest.
My lord, the 7% interest only.
Whatever is the statutory interest, as on the date we are, in 11 years before, it may be less.
My lord, the losses and damages still
We don't.
there. My lord, the damages is.
Only the apex court has said, granted you liberty to go for the interest component. We will be only.
On that basis, kindly.
It simply says seeking a reasonable rate of interest in respect of a terminal benefits, not beyond that.
My lord, kindly see this judgment, my lord.
Yes.
Humble request, my lord.
Yes, please.
My lord, the last para, my lord.
Yes.
I have highlighted the part, the para 3 and 4. Honorable Court has approved 18% interest on that basis for the delayed payments.
That was a different case which requires a composite. Sir, there are, when you say we do not want to enter into this aspect, what do you expect from an employer? If it is a case of a superannuation, there is a certainty in the date. Is it not? The employer knows that my employee is going to demit office on a particular date. He will start all the process before he attained the age of superannuation, so that on a date of superannuation, he is paid the entire amount. Does it apply? Is there any certainty of death or date of death? Nobody knows when he will die. There is no certainty, nor can anybody forecast that on what day one is going to expire. It is really an unfortunate incident that happened to everybody's life.
And that's why they had to.
So they have to immediately, they never expected. So immediately they will take some time to prepare it, the documents. If you rely this judgment has a different connotations.
My lord, but the delayed interest then.
No, sir, this is what Article 142, you must know the distinction between Article 142 and 141. The relief which is granted by the Supreme Court is an exercise of 142, which is not binding on the High Court. It is a declaration of law under 141 which binds the High Court. What is a declaration? If they do not pay within the time, then somebody is entitled to an interest. What should be the rate of an interest is a discretion and depends upon different aspect. What we are proposing is that whatever is the statutory rate of interest which is given, because in such component which the entire amount is given, there is no provision for an interest.
My lord, in my case, there are the delayed payments.
We will grant you only the interest, no compensation, that nothing of that kind.
The gratuity.
We will say gratuity, yes. Under the Gratuity Act, if it is not, we will fix a certain amount. If under the Provident Fund, if it is not a rate of interest, then we will fix our amount. No problem. If it is a statutory interest, then they will have to pay.
Another point is, my father died in service. He was
Sir, a compassionate appointment, what you are talking about, I do not think that you have pursued your remedy here.
My lord, yes, my lord, I have.
No, this you lost. Supreme Court has not interfered with the order, so that order attained finality. So we cannot reopen compassionate appointment issue.
But the management has committed to give it, and it is still open because they have mentioned.
If your term comes, if he is in the wait list.
No, let's. This offer of appointment was given. He was asked to report at Bharatpur. He did not report within 1 month. That was the statutory time.
The case was in under the director of personnel.
Posting to Bhubaneswar rather than Bharatpur.
What?
He insisted that he be posted in Bhubaneswar instead of Bharatpur. Plus, the employer has a right to.
We are not making any comment on that.
But if the employer has already written and it is open, still open, they have replied that.
Yes, they will take care of that. We will be disposing of the matter. Just keep it tomorrow as the first matter. I will dictate it in the open court. Granting that liberty.
Appointment of 169 assistant statutory officer. Everything has been tomorrow.